research cycle and how researchers can avoid infringing copyright and trademark laws before, during, and after the research process, because we always forget about this when we start our research process. But in leading this discussion, we have Carol Cat and Gert van Deventer, and they're both from the Division of Innovation and Commercialization, or in short, just Innovus. So our first speaker is Carol Cat. So I will just be reading the bio. We will have Carol Cat as our first speaker, and this will then be followed by Gert. So Carol is a director for copyright, trademarks, and short courses within Stellenbosch University's Innovation and Commercialization Division, and has been managing the institutional, legal, and commercial complexities and challenges associated with the implementation of and compliance with the applicable institutional policies and legislation within the copyright, trademarks, and short courses environment for the past 20 years. We basically have two very good experts for our speakers this morning. Our second speaker will then be Gert van Deventer, and his expertise is an intellectual property specialist, copyright and trademarks. Now, Gert provides support in regulating Stellenbosch University's trademark portfolio, and he assists in institutional copyright matters. He completed his BSc in molecular biology and biotechnology, but then his interest changed and he decided to do his LLM degree in intellectual property. However, he didn't stop there. He's currently enrolled in our LLD program and is focusing on trademark law. So without further ado, I'm going to hand over the mic to Carol, and I'm going to switch off my camera. So Carol, whenever you're ready. Thank you.
Thank you. Good morning, and thank you very much. And thank you for this opportunity to allow our office to come and speak to you this morning and share our thoughts and I won't say expertise, but let's say our knowledge regarding trademarks and copyright. So I just want to check, can you all see my screen?
Yeah, it's all good. Thank you, Carol.
Great. All right, so as Paulette has explained, Gert van Deventer is with me this morning. I'm going to be dealing with copyright aspects, and then Gert is going to be dealing with the trademark aspects, how it all relates throughout your research process, and it is within your early, your mid, and your late stages of research. There are different copyright and trademark aspects that you need to actually be aware of, and that you are able then to fulfill certain obligations or permissions or whatever you may require to proceed. We are not going to involve you this morning with a large debate regarding what copyright is and what trademarks are, because I'm pretty sure that by now you do know what the word copyright means, and I think you are aware of what trademarks are, especially after the institution has gone through a whole brand refresh process. But what we are going to focus on is how this affects you while you are doing your research within the institution and within Stellenbosch University. So let's have a look at certain factors regarding this. Gert, my slide is not presenting.
Taking control. There we go.
Thank you. I've got control. Thank you. Right. So now, intellectual property. What is intellectual property? It doesn't just consist of copyright and trademarks. It consists of patents, it consists of plant breeders' rights, industrial design rights. So there are different facets to intellectual property. But for you today, the important factors that we are going to focus on is going to be copyright and trademarks. And intellectual property is a product of your human intellect. It's your creativity, your ingenuity, your innovation in what you are creating, and it does qualify for legal protection. Copying and distributing any form of IP, copywriting content, trademarks, anything that you use in excess or without permission in respect of intellectual property is actually a misappropriation of intellectual property. There is an associated economic and a moral right regarding intellectual property. So if you are doing anything without permission and in excess, and not just the misappropriation, you're affecting somebody's economic and somebody's moral right as well. Now, in an academic institution, we are both users and creators of copyrighted material, and we are large-scale users and we are large-scale creators. So in academia specifically, you're focusing on using copyrighted material, distributing it to your students, putting the information out there in course modules. In research, your focus shifts. It shifts to what you are using, your literature reviews, everybody else's content that you're using. Then you're going to progress to publication where you're going to require protection. And in some instances, you may even be commercializing your research. So that is why it becomes important to you. Within the institution, we have got processes regarding the identification of copyright, regarding administration, management of not just our own intellectual property, but any third party's intellectual property that you may be using. And at this stage, you could possibly be using somebody's journal articles, somebody's internet content, somebody else's research. So it's a two-way street, this. We use and we create. So the protection of our academic activities is resulting in us not being infringed and us not infringing. And this applies throughout our teaching, research, and academic publication spectrums. So now we have a look. Our division as such is responsible for a number of policies within the institution. We are the custodian of not just intellectual property, but you can think regarding any form of commercialization within the institution. Right, it still doesn't click on my side.
Here we go.
Right, so we've got an intellectual property policy. I don't know if you're aware of an intellectual property policy. The first policy was drafted a number of years ago, but we have subsequently reviewed this during the course of 2022. And since January 2023, the university's new intellectual property policy, the revised edition, is now applicable. Most importantly, during your research and during your course of your duties at Stellenbosch University, we earn the copyright in work that you create in the course and scope of your employment at the university, and this includes intuition and research and community interaction initiatives. But we also earn the students copyright in any works they create in the course and scope of their studies at the university. This assignment of copyright to the university by the student takes place on registration, and it includes all works that they create throughout the course of their studies at the institution. These rights that are now assigned to Stellenbosch University and that vest in the university give us an exclusive right as an institution. It gives us the right to exploit, to use, and to enforce protection of the research that you are creating. We are also custodians of the trademark policy, and Gert will give you a lot more detail regarding this, but it does facilitate and regulate and maintain the use of licensing of our trademarks for both commercial and non-commercial purposes. So we work very closely with our corporate communication and marketing division. We are responsible for the use and licensing of our trademarks, but the corporate communication and marketing division is responsible for the visual approval of the use. So in other words, that the correct format, font, logos, Pantone colors, that's their role. But our role is more the legality behind the use and the licensing of trademarks. So it is a form of intellectual property, and it's one of our most valuable intangible assets as an institution. It's very closely linked, obviously, to our academic reputation, and it is making us one of the leading research-intensive universities within South Africa. So we are going to protect the use of our trademark to a great degree. So now we look at the early stages of research. And in copyright, your early stages of research are basically still you're at the idea, the concept stage. You're starting to look and browse literature. You're starting to review. You're starting to look at the content that you can potentially collect. But while you're busy doing this, be mindful of the following things. Because if you're going to be using material in which we do not own the rights, in other words, journal article, data sets, images, graphs, software, we're trying to prevent unintentional infringements. So we let you understand, or we lead you to understand the following. There is a provision within our Copyright Act, which I just want to admit here is severely outdated. It was an act from 1978. It has been reviewed and it has been updated, but it has not made provision for all the technological advancements currently in the research environments or any other copyright environment. But for now, it is that very outdated copyright bill that applies. They are in the process since 2015 amending the Copyright Act, but right now it has not been signed into Parliament, and so we are still leaning very heavily on a very outdated piece of legislation. So within this Copyright Act, provision is made for what they call fair dealing. But fair dealing allows you as a researcher to make a single copy of a piece of work for purposes of private study or research. However, it doesn't tell you how much you are allowed to utilize, but you are allowed to make that single copy. But it also doesn't lead to distribution. So if you're going to be including any third-party content going forward in your thesis or in your publications, you've got to be very careful then that you have the necessary permissions, because fair dealing does not extend to multiple distribution. It only extends to private research and study purposes. Another factor that you must consider during your early stages of research is that keep all your sources information, because you have to give proper acknowledgement and attribution when required to do so. So keep a good log of that. You will need to seek permission from certain copyright holders or owners of publications while you're busy with your literature review. Look at what you could potentially be using and where you're potentially going to be needing to request permission. There will be provisions as well where you may need to be licensed, and we've seen this especially when you are doing, let's say, research and you're gathering information and you need a tool or you need an instrument and you use somebody's questions that they've already asked in a research project. Potentially, you may have to be licensed to be able to use this questionnaire in your research. We caution you when you use internet resources as well, because different websites have different terms and conditions. Don't just assume it's on the internet, it's freely available, and I can use it as I may. There are specific terms and conditions regarding downloading, distribution, academic or commercial use, and for private study or not. So just be aware of what your terms and conditions are in this regard. Now, as you know, we've got a wide variety of open educational resources which you can use and reuse. There's not normally a charge associated, and it's potentially going to allow you to adapt the content, but there could also be limited or restricted rights, but there can also be unrestricted rights. So here again, when you access that open educational resource, check what you may and may not do with the content. They normally very clearly stipulate that you are free to use, adapt, modify, commercial distribution. The commercial factor comes into play when you start publishing and you start, especially if you do a book publication, where there will be royalties involved. Have a look if you're using Creative Commons licensed material, which is also on open access. There are different licensing provisions which allow you to either make amendments, which allows you for commercial distribution. Some instances you can adapt without permission. Some instances you don't even need to attribute. Make sure of what the terms and conditions are when you're accessing Creative Commons licensed material. There's also material available in the public domain. Now, in South Africa, material normally falls into the public domain the life of the author plus 50 years after the death of the author. So it lasts for the lifetime plus another 50 years. Be careful when you're using co-authored content, because then it is 50 years after the death of the longest surviving author. So there are no exclusive intellectual property rights that apply unless you're free to use the content. But we are cautioning that you make sure the work explicitly states that it is in public domain and it is free of copyright and may be used without restrictions. Because don't just assume that work that's expired after 50 years after the death of the author automatically falls into the public domain. Make sure it's not lying within an estate that it's been bequeathed, that the rights have been assigned or transferred. So just make sure the work explicitly states it's in public domain. Now we look at the middle stage of research. So now you've gathered all your data, you've looked at all your literature review, so you've gone through all the content that you're going to potentially be applying. So what's going to be applicable now as you progress into your next stage of research? So now you're going to start generating your own material. So now you're taking all your notes, all your preliminary drafts, codes that you could be possibly developing. You need to then understand the automatic nature of copyright and ownership. So the minute you put all of this material that you've collected into a tangible format, in other words, you've put it onto your computer, you've written down all your notes, copyright subsists automatically the minute it's in a tangible format. So that copyright is already existing while you're busy creating this work. No matter how many times you change it or you amend it, or you adapt what you've put in, every time it comes into a tangible format, copyright is now subsisting in that work. So now you are starting with your creation of your research deliverable, and these are your results, your reports, your databases. And this copyright that you have created, either as a staff member or a student, is vesting in Stellenbosch University. So we caution you upfront, determine ownership of your material way in advance, and your rights management, especially if there are partnerships that you are entering into in your research. If it involves multiple contributors, outline ownership of who's contributing what, especially when you get to writing a journal article. Make sure you've outlined who's contributing what, who owns what, and make sure that you have the applicable usage rights in place if you need somebody's permission to include the material in your writing or your publication. Another note is that as a research student, you may be granted a scholarship or a bursary from outside organizations. So we may not transfer as a student these rights directly to the person providing your bursary or your scholarship. You've got to consult the clauses within our intellectual property policy. It will tell you very clearly what the process is, so that you will have to consult with our office, with our technology transfer and innovation commercialization branch, as to what you may and may not do when granting rights to these outside organizations. Students may not do it on behalf of SU. Another factor is regarding software or novel data compilations. And these are your potential deliverables within your research. Acquaint yourself with the copyright protection that you're going to require. And this is unpacked very carefully within our revised intellectual property policy, because there are specific clauses regarding software and especially open access software. So have a look at those clauses within the policy. At this stage of your research, you must also be thinking what you're going to be doing in the future. Are you going to be commercializing your research? Are you going to be looking at publishing options? Are you going to be putting this into a textbook? So you've got implications for your copyright, for ownership, for co-authorships, for licensing, and all your open access relevance is also applicable. So this is where in your process of your research, you start thinking about these aspects regarding the ownership of your intellectual property. Now you've progressed through the research stages and you're now in the latter stages of your research, and the end is in sight. However, there are a couple of things here to bear in mind. As a researcher, consider upfront the possible future use and dissemination of your research. This is where you start looking at potentially if embargoes are going to be placed on theses, depending if it's going to be sensitive research. You navigate publisher agreements. You're going to be looking at publishing in journal articles. You're going to be looking at book publications. Understand what the assignment or the transferring of your copyright means, and also negotiate with your publishers for what we call retention of rights. In other words, you're allowing yourself as an academic and researcher to make use of this content that you are creating going forward. A lot of these publishing agreements want exclusivity, and it inhibits you as a researcher to further use the content that you've created. So we warn you to choose a specialized academic publisher, and you want somebody with a high quality end product. Avoid mass vanity publishers, and you will be targeted. You'll be targeted on social media. You'll be targeted via the internet. They do not conduct peer review processes, and there are very few editorial processes. They normally want exclusivity for all versions of your work. And they will also, somewhere in the process, just ask you for your bank details, not that you will ever see a substantial royalty out of it. So we advise you to try and achieve a workable compromise between yourselves and the publisher and between SU, bearing in mind that we would need to grant you permission to use the work that you've created within a publication. Since we are a research institution, we want to disseminate our research as widely as possible. And this is why we caution regarding exclusivity. We don't want to, by granting exclusive rights, for it to interfere with your primary function as a staff member and as a researcher as well at the institution. If your research has got a commercial potential, we advise you speak to the members of staff at our technology transfer office, because you have to understand how copyright protects your software, your databases, and created works for licensing and for technology transfer. So we advise you to collaborate with our office. We can discuss the possible intellectual property clauses that would be applicable. What protection are you going to need? Do you need to move to disclosure, especially with patents? Strategies for commercialization. We're there to assist you as the researcher, and we're there to protect your interests and to protect the university's interests. Now, SU is a creator of intellectual property, as you've heard previously on the slides. So copyright in works in context of our publicly financed research and development vests in SU, and that is according to our Intellectual Property Rights Act within South Africa. All the copyright in your research-related materials created by the course and scope of your duties vests in SU, as I cannot emphasize that sufficiently. However, even though the rights in that material rest within SU, the income from it in your artistic, literary, and musical works, we don't claim the income, we do not claim the royalty, even if it is created pursuant to your duties as an SU staff member. I think you can imagine the amount of publishing that takes place if we have to now have a specific office just dealing with all the royalties and income that can be generated from research. Copyright in academic textbooks. If you've been asked to write an academic textbook or contribute to a chapter in an academic textbook or academic articles, we don't claim that. That still vests in staff, but we will advise you that SU must be suitably knowledged in your publications. We advise you to contact our office if you want assistance when you are dealing with publishers to make sure that your publication that you are proposing does align with the current clauses within our intellectual property policy. And we also emphasize that all transactions by staff regarding copyrighted works that they've created, in other words, if you're negotiating with your publisher, you're concluding it in your own name and it's for your own account and responsibility. And for that reason, we also do not share in the royalties of that work. Now, we've gone quite, I'd say almost on the surface, I've touched on your copyright in the research process, but we haven't touched on the elephant in the room, namely AI and copyright. We are normally averse to giving our opinions regarding AI and copyright, especially in the research environment. Your AI chat box and your image generators reproduce and adapt copyright materials without permission. So there are ethical and legal considerations, including transparency, data privacy, security, confidentiality of your research participants, and copyright infringement and plagiarism risks. Those are the risks associated with it. But there are institutional guidelines that have been drafted regarding the use of AI-generated content, and I would advise you to consult these guidelines. They give you quite it's a bird's eye view, an overview of it, and we did provide input regarding the ethical and legal considerations. You just have to be cautious, and when you're using AI-generated material, don't slavishly copy and paste from what was generated. Try and avoid infringement by using Slavic copying and pasting, because you don't know what copyrighted material is lying behind that AI-generated content. And we advise you to declare and acknowledge the AI that you've used, and also to cite the prompts that you use to generate the content that you received. There's a large volume of material out there that's been reproduced and adapted from pre-existing copyright material without permission from the copyright holders. And there are a number of litigation issues internationally with major AI companies, and they've been drawn into these legal disputes with both authors and publishers. So just a couple of news clips that have recently been popping up throughout this year. We had a couple of attorneys that cited AI-generated law cases in a law case in, I think it was in Pietermaritzburg, so where subsequently the judge picked up that there were no such law cases that were AI-generated. And as you can see, there are a couple of cases where we have legislation with defamation, privacy, and copyright infringement issues. So on that AI note, I'm now going to hand over to Gert van Deventer so that he can advise you further regarding the trademark use.
Good morning, colleagues. Carol, thank you for that handover, and Paulette, thank you for that brief introduction earlier. So, colleagues, moving from copyright to trademarks, just perhaps a brief introduction into what is a trademark. So, as Carol has mentioned before, and similar as with copyright, trademarks are also a form of intellectual property. And under our South African legal system, trademarks are typically seen as being, or as being mentioned, as being creatures of statute, meaning that it is primarily derived from legislation. Our legislation provides for this definition of what a trademark would entail, and it indicates that it could be any sign that you are capable of representing graphically. So if you are able to put pen to paper and draw a sign, you could potentially be eligible to have trademark rights in that specific sign that you have represented graphically. Trademarks are primarily used to distinguish between different goods or services. So it's used in the marketplace to draw a distinction between your product or your service and that of a competitor. Other functions of a trademark that you might also be familiar with and recognized through the years by our course is that trademarks also signify a certain level of quality that is attached to that specific product or service. And then also, and this is specifically prevalent in Stellenbosch University's case, specifically for our branding, trademarks are also used as a way to advertise or promote the products or services that you are trading under that specific trademark. So Interbrands, Interbrands is a leading brand consultancy firm, and they usually release their top or best global brands for each year. And at the beginning of the year, they've released the following listing. You will see here Apple, Microsoft, Amazon, Google, and Samsung were regarded as being some of the best brands from 2024. And these ratings are typically based on the brand value of each of these marks. So determining the brand value, they would typically look at the sales revenues for the products and services being sold under these marks, the profitability that are attached to these marks, the market share, the value that these marks hold within the market, and then also brand recognition or brand popularity. So how popular these specific marks would be in the market. Perhaps just for interest sake, bringing this closer to home, you would know the university underwent a brand refresh process in November 2020, November 2019. And at that stage, specifically by looking at the university's overall brand portfolio, our brand portfolio was estimated to be approximately 3.07 billion rand. So there is quite a bit of monetary value that you can attach to the university's overall brand portfolio. That's just for interest's sake. Now, also specifically in relation to the university's trademarks, our trademarks or all trademarks are governed by certain national frameworks or national legislation specifically, as well then, and instead this is specifically for Stellenbosch University, there we have also certain institutional policies and institutional guidelines that regulate the use of our marks. So not going into much detail into this, under national legislation governing our trademarks, we have our Trademarks Act. So our Trademarks Act provides for a system by which you would be able to register trademarks, and as well as it would provide you with certain mechanisms by which you can enforce your trademark rights. Important to note here, all trademarks are registered or can be registered in 45 classes of goods or services. So any good or any product or any service that you can possibly think of can be allocated to one or more of those 45 classes of goods and services. And then should your competitor, as an example, use an identical or a similar mark to the one that you've owned and that you've registered in relation to similar goods or services, again referring to those 35 classes of goods or services, that might constitute trademark infringement. And then according to our Trademark Act, you would be able to institute legal action against that specific competitor. Also, national legislation that are applicable to specifically trademark rights for tertiary institutions, as well as in Stellenbosch University's case, we have our IPR Act. So our IPR Act specifically addresses IP ownership and use in relation to research and development that results from state funding or government funding. Trademarks are specifically mentioned in the IPR Act's definition of IP. So therefore, any trademark rights that results from research and development that are publicly funded would be owned by that specific institution. So any, bringing this closer to home to Stellenbosch University's case, any trademark rights resulting from research and development would be owned by Stellenbosch University. And then depending on the commercial viability of that specific trademark, as well as the other inventions that it is used for, the technology that it is used for, it would be subject to certain IP transactions. So it would be licensed to an industry partner or to a spin-out company. And the goal of this is to benefit society. The goal of our IPR Act is to benefit society. So trademark rights resulting from research and development should then also be used to benefit society. And then on an institutional level, our trademark policy reiterates the position from the IPR Act, indicating that any IP resulting from research and development would be owned by Stellenbosch University. And our IP policy also prescribes certain invention disclosure processes by which you would need to disclose a technology that was developed, as well as the trademark rights. And it then also provides for benefit sharing, specifically for the institution, as well as the original creator of that specific technology and trademark. And then Carol has briefly referred to this in her part of the presentation. Our trademark policy After extensive consultation and approval process in 2022, we were able to implement our revised trademark policy at the beginning of 2023. And our trademark policy primarily deals with the correct use of the university's trademarks, and it also provides for avenues through which you can make the university's trademarks available for commercial licensing to external stakeholders. And then all of you, I'm guessing, would be familiar with our brand identity guidelines. The university completed its brand refresh process in 2022 and implemented revised brand identity guidelines at that stage. And our brand identity guidelines provides for specifically our brand marks, how our brand marks should be visually applied. If you are not aware of Issue Corporate Communication and Marketing's website, please, I urge you to visit their website. They have specific prescribed templates that you can use that shows the university's brand mark specifically, as well as how you would need to apply that visually. So the university's trademark portfolio can typically be divided into 3 different categories of trademarks. So firstly, and this is what I've mentioned earlier, we have our brand marks. So these are the marks that you will see in the university's brand identity guidelines, and basically all of those marks would contain this specific S Shield logo. This is the unified mark that needs to be shown in all of our brand trademarks. Then we have marks that relate to issue entities, initiatives and projects. Just as a point of departure, specifically here for initiatives and projects. After our brand refresh process, these entities are no longer allowed to use their own unique marks, specifically to prevent that our brand marks or that our marks are fragmentized. So, but however, there are certain exceptions, specifically for initiatives and projects. I will get to that a bit later, but where certain initiatives and projects would, however, still be allowed to use and have unique marks. I will get back to these examples a bit later. And then a third category of marks is marks that relate to our university's group of companies. So these marks would typically then be licensed to the group of companies that would then enable them to use these specific marks for their names, as well as for the products or services that result from those companies. So jumping into research specifically. So in the early stages of research, you would typically be busy with basic research. So you would look at generating new ideas, new concepts, doing literature review. And at this stage, and this is specifically for technology and product development from research at development, at these early stages, you could foresee the possibility that there might result a product or technology from the research that you are currently busy with at that specific stage. So these typical products, or these would then also, or there's a potential that you can, even at this early stage, see that there might be commercial external use of these specific trademarks. So in this case, and this is what I've mentioned earlier, these products or technologies that might be used externally and as well for commercial purposes might be allowed or may be allowed to have and use a unique mark. So at this stage already, you can consider creating a mark or creating a word that might be distinctive for your specific product, even at this early stage of research. Something that I've mentioned earlier, one of the requirements for you to be able to register a trademark is that it must be distinctive. So you must be able to distinguish, or trademark must be able to distinguish your products or services from that of a competitor. And a trademark would typically be distinctive either inherently or through the prior use of that specific mark. I'm specifically in this instance going to focus on inherent distinctiveness. So you need to create, or you need to look at trademarks that are inherently distinctive. So here are some tips that you might consider when looking at or when creating an inherently distinctive trademark. So important to note here, you need to be inventive when you create a name or a logo for your specific product. So look at words that are coined or fanciful or arbitrary, made up words. A great example of this is Google. Google is a made up word. It's there's no existence of it prior or in the English language. So look at these terms that are made up that you can potentially use as a mark for your specific product. And then also importantly, steer clear of any descriptions. So a mark should not merely be descriptive of the technology or product that resulted from your research. Another factor that you need to take into account is make sure that the mark that you select or that you create are not merely a derivative of previous marks that are already in the market. If you are using a derivative mark or making or basically copying a mark that is already in the market, that might or could potentially lead to misleading impressions or confusion. So make sure that you steer clear of this as well, so that there's no misleading impressions or confusion in the market when you use your mark. Then important to note here, to determine whether a mark is misleading or confusion, you need to consider how your reasonable user of that specific product would interpret or would see this in the marketplace. So you need to consider the overall impression, specifically in relation to a competitor's product or service that are already in the market. When looking at overall impression in the market, you need to consider 3 factors that you need to take into account here. Firstly, visual, whether there are any visual similarities, phonetics, so how the mark sounds, and then as well as conceptual. When looking at conceptual similarities, take into account translations as well. So merely translating a word. A good example of this is a case that came before our courts a few years ago, is the magazine Getaway and its competitor using a translated version, Wegbrek. Even though there were no visual or phonetic similarities between those marks, there were definitely conceptual similarities. So in that case, the court ordered Wegbrek to change its name due to its conceptual similarity to the magazine Getaway as a translation. of that original mark. And then also something that you can consider here when you are creating or looking at new marks or to create marks, do you do some informal internet searches beforehand? Check whether that specific mark is not maybe already used in the market and that you perhaps are not yet aware of. And then in some instances, specifically in early stage research, you might have certain partners or external entities that are involved in your research and that also then require recognition through the use of their mark within your research endeavors. So firstly, check whether there are any contractual relationships between you or Stellenbosch University and that specific external entity. Specifically, a good example of this is funders. So make sure whether there are any contractual relationships, whether trademark use are addressed in those agreements, and make sure that you comply with that. And check also what specifically would their contributions be before allowing them to be recognized within your research. Important notes just on this specific point. Where you are using third-party marks, specifically in your research, check whether you require their prior approval or that specific entity's prior approval before using it. And important to note here as well, check whether they have brand identity guidelines on their side as well. Most external entities these days, similar as Stellenbosch University, have brand identity guidelines that you would also need to comply with. So make sure when using third-party marks that you comply with their requirements as well. Getting to mid stages of research, this is typically where you would go over to applied research, and then as well where there would typically be technology development or product development, and as well as where you now definitely foresee that there might be commercial applications of your specific technology. So according to our IPR Act and IP policy, there are certain invention disclosure processes that you need to follow that would be done through the university's technology transfer office. Typically, you would need to, within 90 days of an invention, make a disclosure to the university's technology transfer office, where you give a description of your technology, and then include it in this disclosure. You would also then, or you could then also make reference to a potential trademark that you have been working on. When the our technology transfer office receives this disclosure, they will check it. They will check the commercial viability of your product as well as that specific trademark, and then they will liaise with our office, the trademark office, and then our office will liaise with our external trademark attorneys, and then we can start the formal processes to register that specific trademark. Firstly, we will ask for that certain registrability searches first be conducted. So these registrability searches allow you to check for any prior marks that are already in the market. And this is also a risk mitigating factor. So by doing these registrability searches, we can check whether there are any prior marks, and then also whether that specific project would need to change their mark should there be already a prior mark that are similar in the market. If the mark is available, we would proceed with registrations. And then the CIPC's trademark register will look and examine that specific registration, and then subject to the registrar's acceptance and the publication of that specific trademark in the patent journal, you can the registration certificates will be issued, and the mark would then be regarded as being registered. Then getting to late stages of research, the product will now be brought to the market together with that specific trademark, and this would typically be done through a commercial strategy via a technology transfer office. So this would typically be licensing to an industry partner or to a spin-out company, and a trademark license would be included in that specific technology licensing agreement. And that specific trademark license would then be subject to our trademark policies provision. A trademark or a license fee would be charged through that specific technology and trademark license, and any benefits coming from that specific license would then be divided through a benefit sharing formula that will flow to the original creator of the IP as well as to the institution. And the idea of this is that the technology and the trademark would be used specifically for society's benefit. So a trademark in this instance would be benefit society by reducing the search cost in the market, and also preventing misleading impressions or confusion within the public regarding similar products or services that already exist within the market. And then afterwards, the Technology Transfer Office will report to NIPMO, the governmental body representing the Department for Science, Technology and Innovation, on trademark rights that flowed from publicly funded research and development. Now, just to close off a few examples, this is what I've mentioned earlier. You will see here on the slide, Sporatech and Framing Mobility are two of the university's current issue projects. They are allowed to use their own unique marks, specifically due to the fact that they would be used externally and for commercial purposes. Aroba Biotech and Biotrek Systems are two of the university's spin-out companies, and they are also, again, this is focused on commercial external use. So they would, under license agreements to these two companies, be allowed to use the university's trademarks in those instances. And that is it from my side, trademarks in a nutshell. Carol, I don't know if you have any last comments to make. Otherwise, I think we can open the floor for a few questions. I think there's 5 minutes left.
Thanks, Clark. No comments from my side. There was one question in the chat which I've answered in the chat. But if you need, I just want to add to what I have answered. If you need assistance with that, please contact us. We will be able to give you assistance in trying to trace a holder or copyright owner of a tool or instrument or questionnaire for which you need permission for ethical clearance.
Any other questions, colleagues?
Okay, let me just move myself over. Sorry, I've got about 3 screens here, so let me just look at the camera. Okay, so if we don't have any more questions, I would just like to say thank you to our speakers for taking time out this morning and presenting this morning. It was definitely I assume, well, as Carol said, she skimmed over the top, so I'm assuming Gert is also skimming over the top here, but it is definitely a lot of information. So if you have any more questions, I'm on this site now. It's nicely laid out, so you guys can just go there and look at the policies and guidelines, but I'm sure between Gert and Carol, they won't mind if you contact them. Like I said earlier on, we have this session recorded, so it will be available on the library's YouTube channel, but there will also be a link on the library's website. So the same space where you found to register for this morning's session, it will eventually change next week to where you can get the link. So again, for Gert and Carol, thank you again for doing this morning. I actually also had a question, but I don't want to waste your time on it. So I'm just going to quickly pop it for you, both of you guys, or or just for Carol. Carol, you spoke about 50 years after the last, co-author that copyright still stands. But I want to know about the raw data. I'm talking about from the lit review to creating your database or, creating your Excel spreadsheet or whatever before it starts becoming a product that eventually is either publication or it becomes a trademark or product or service. How long must that owner keep that raw data? Just for verification to say that you own it, in the sense that somewhere along the line, there might come a time when somebody says, oh, but I thought of that name or that product 20 years ago or 10 years ago. So how do you as an owner then say, no, but look, I did it 5 days before you did it, just hypothetically speaking. So how long does an owner keep their raw data to make sure that, two minds think alike do not overlap in the end?
Look, it's a difficult question to answer you how long, but if it's in a tangible format and you've captured your data, you basically can enjoy protection for 50 years after the date that you've created the data. However, what you must also bear in mind that when you are archiving your data here as well, put the date on which you captured your data. It's quite important if you get involved in a wrangle where somebody says, oh, but I discovered it 5 days before you, where you have put a date on when you've captured your data and you formed your analysis. That is your first date of when you put it into a tangible format. So you will be able to prove that you actually created it 5 days before the other if you've captured the date of creation. Yeah.
Okay, thank you. Colleagues, with no further ado, thank you again, everybody, for speakers and for our audience that made time this morning. I wish you all a good and blessed day. Bye, everybody. Thank you again for coming. Bye.
Bye.
Bye-bye.